Good afternoon and welcome to First Amendment Auditors Urban Legends Part 2. Today we are going to look at, can a private company or private individual deny you your First Amendment right? The quick answer, the short answer to that is no. Carpenter v. Scott addressed that, and they held that an alleged conspiracy to infringe on the First Amendment rights is not a violation of 1985 Section 3 unless it's proved the state is involved or the aim of the conspiracy is to influence the activity of the state. At this point, you're going to wonder what 1985 subsection 3 is. Well, in order for someone to violate your right, you have to have a way of protecting your right. You have to have a cause of action. So there's two basic ways that your rights can be protected. One is through a criminal statute. If you remember, we've talked about 18 U.S.Cs. Those are criminal codes. There's 242. This, if anything, is what the officers would be charged in the Olmos Park case. They would not be charged with assault. This is what a prosecutor would go after them for. But this is state action. So whoever under color of law, statute, ordinance, regulation, or custom willfully subjects any person in any state, blah, 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 to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or different punishments, pains, or penalties on account of the person being an alien, or by reason of his color, race, then are prescribed for the punishment of citizens, shall be fined under this title or imprisoned not more than 1 year, or both. So, now, admittedly, this doesn't only affect the governments, like the state governments or local governments. It also would extend, like if a sheriff gathered a posse to go out and, deprive someone of rights as part of the posse, then private citizens would be liable under 242, or not liable, they'd be culpable under 242. But the one where you can get a private citizen is 241, conspiracy against rights. So this one doesn't require action by the state. This one says if two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premises of another, with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years or both. So there's no state action required under 241. So this is, I didn't mean to click that. This is one possible way where you can get, where you can enforce a right against an individual, a First Amendment potential right against an individual. Or this is where the state would protect your rights, I suppose. Then there's the tort versions. There's 1983. Everybody's familiar with this. This is the tort cousin of 242. Every person who, under color of any statute, see we're back under the color of statute, ordinance, regulation, custom, or usage of any state or territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or any other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable. This is a tort to the party injured in an action at law, suit in equity, or other proceeding for redress. But because it's under color of statute, once again, this requires state action. So you could, again, sue, say, the member of the posse who went out with the sheriff to deprive someone's rights. But there has to be that state actor involved. And then there's 42 U.S.C. 1985. This is conspiracy to interfere with civil rights. The one that we're going to look at, we're not looking at preventing an officer from performing duties because that wouldn't be a First Amendment deal. We're not looking at obstructing justice, intimidating a party, witness, or juror because that's not a First Amendment deal. We're looking at depriving persons of rights or privileges. And once again, this is going to be the kissing cousin to 241. If two or more persons in any state or territory conspire to go in disguise on the highway or on the premises of another for the purpose of depriving, either directly or indirectly, any person or class of persons of the equal protection of the laws or of equal privileges and immunities under the laws, or for the purpose of preventing or hindering the constituted authorities of any state or territory from giving or securing to all persons within such state or territory the equal protection of the laws, or if two or more persons conspire to prevent by force, intimidation, or threat any citizen who is lawfully entitled to vote from giving his support or advocacy in any legal manner toward or in favor of the election of any lawfully qualified person as elected for president or vice president, or as a member of Congress of the United States, or to injure any citizen in person or property on account of such support or advocacy, or in any case of conspiracy set forth in this section, if one or more persons engaged therein do or cause to be done any act in furtherance of the object of such conspiracy, whereby another is injured on his person or property, deprived of having and exercising any right or privilege of a citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. So this is a tort where you can sue a non-state actor for any deprivation of equal protection of the laws or immunities under the laws. So these statutes all came about in the aftermath of the Civil War. They were originally designed to protect the newly freed slaves from the ravages of the KKK. And that's why they read in the way they do. Congress was trying to give people a federal right to protect any rights that maybe the state wasn't adequately protecting. So we're going to start looking at some case law because it's great to read these things, but we don't know what that means. You can say, well, obviously, if someone is conspiring to deprive me of my First Amendment right, it fits in to the 18 U.S.C. 241 or 1985 subsection 3. So I should be able to sue, or they should be criminally culpable. Well, so the first thing you do is you look at the statutes, and then you have to look at any cases that deal with those statutes, because the cases are going to tell you how to interpret the statute. So the first case we're going to look at is U.S. v. Williams. Now, in the U.S. v. Williams, it's not really an important case, but it does kind of start the ball rolling. This is where 18 U.S.C. 241 kind of gets its beginnings in the court. And in this court, it was a split decision. You'll notice here that Frankfurter, the Chief Justice, Jackson, and Minton were of the opinion that 241 only covers conduct that is expressly arising from the substantive powers of the federal government. So that would be any statute that Congress passes that gives people a right, like the Homestead Act, or the 13th Amendment, where it protects your right against being a slave. That is something that Congress has the power to deal with. So, but not the 14th Amendment. And the reason why they didn't think the 14th Amendment applied was because the 14th Amendment only applies to states. Now, 4 judges, Douglas, Reed, Burton, and Clark, dissented. They thought that obviously, because of the time frame, this is right after the Civil War, the 14th Amendment was passed, and Congress was looking to give people a means to enforce the rights that the states weren't enforcing. and the federal government was trying to give the federal government rights to enforce rights that the states weren't enforcing. So they thought, obviously, the 14th Amendment has to be involved. Well, I believe it was Black concurred in the judgment, but only on the grounds that these four guys, Frankfurter et al., arrived at the correct decision, but he thought that decision was justified because of res judicata. He thought that they shouldn't even deal with the 14th Amendment part of it. He said they've already been tried once and acquitted, and then they were trying to be tried again, so it was done. They shouldn't be dealing with it. So it's very much left an open question on whether or not the 14th Amendment applied. Then we go to Collins v. Hardiman. This was in the same year. And Collins v. Hardiman, instead of dealing with 18 U.S.C. 241, Collins v. Hardiman was dealing with, this is the precursor, this 8 U.S.C. 47.3 was the precursor to 42 U.S.C. 1985, subsection 3. So they're essentially the same thing. I think they even read the same. But what they held was that conspiracy has to be for the purpose of depriving the plaintiff of equal protection of the laws or equal privileges and immunities under the law. And in this case, what it was is there was a political club that, this is in 1951, it's just after World War II. There was a group that was going to protest the Marshall Plan, and I think they were communists, and this group decided that they were going to bust it up. And so what the court held was that the conspiracy has to be for depriving people of the equal protections under the law, and just disagreeing with someone on political issues doesn't mean anything in particular. So they busted up. It was a group of white people bunching up a political meeting of another group of white people. So they were like, well, you know, it's not just to protect people from a political brawl. It's to protect people's equal rights and privileges. So that was one thing. But another reason why I'm bringing up this case was the dissent. And the dissent pointed out that they did, in fact, state a cause of action, because they were saying that the right alleged to have been violated is the right to petition a federal government for a redress of grievances. This right is expressly recognized by the First Amendment, and this course has said that the very idea of a government republican form implies a right on the part of its citizens to meet peaceably for consultation to respect to public affairs and petition for a redress of grievances. So what the dissent was saying is that you don't even need the 14th Amendment. There is a direct cause of action to protect your right to petition the federal government. But this was the dissent. And that's kind of where this one falls on its face. The majority didn't hold that, so this is meaningless. No subsequent cases have picked it up. And in fact, when we get back to Carpenters, we're going to see that the court looked at it only through the lens of the 14th Amendment, where the states can't infringe on your First Amendment rights. So from there, this was Collins v. Hardiman. From there, we're going to U.S. v. Price. Now, this is a very famous case. This is in 1966. This is the basis of the Mississippi Burning movie. In this case, there were 3 law enforcement officials and 15 private individuals who took people out of jail at night and killed them because they were black. And they wanted to punish them. So in this particular case, we're looking at 18 U.S.C. 241. So we're back in the criminal portion of it. And what this held is somewhere down in here, section 2. As we have consistently held, the 14th Amendment protects the individual against state action, not against wrongs done by individuals. In this case, the participation by law enforcement officers, as alleged in the indictment, is clearly state action, as we have discussed, and it is therefore within the scope of the 14th Amendment. So they say that because Williams won, there's another Williams v. United States where they're working on the Section 242, and that's Williams 2. This is Williams 1. So in Williams 1, they're saying that the court left it undecided because it was a split decision, 4-4. And so what they said is that absolutely it does reach the 14th Amendment, but the 14th Amendment only protects the individual against state action. Now in this case, in this particular case, Section 241 does allow the prosecution of the individuals for the violation of the 14th Amendment right to due process because there were the 3 Mississippi law enforcement officials that participated in it with the private individuals. They conspired, because remember it's got to be a conspiracy. They conspired to violate the 14th Amendment rights of these 3 victims. So okay, well anyway, so the 14th Amendment applies because there was state involvement. From there, we're going to move on to Griffin v. Breckenridge. This is a big one. This is a very important case. So what they held in, this is in 1971. This is where a group of people went out and they assaulted a group of black folks who were traveling on the highways. And they went there for the purpose of preventing them and other Negro Americans through force, violence, and intimidation from seeking the equal protection of the laws and from enjoying the equal rights, privileges, and immunities, etc. Now, what they held in Griffin is that the language requiring intent to deprive equal protection or equal privileges and immunities means that there has to be some racial or perhaps otherwise class-based invidious or invidiously discriminatory animus based on the conspirator's action. So it needs to be based on some kind of protected class. They don't go into a lot of detail on it, but they say it's got to be based on a protected class. They have to be doing it because of that. They have to intend to do it because of the class. And the second thing that they held is that Congress has to have the power to legislate the underlying right. There has to be a basis in the Constitution that grants Congress the power to legislate on that particular thing. So our inquiry therefore need go only to identifying a source of congressional power to reach the private conspiracy alleged by the complaint in this case. All right, so down in here somewhere, I'm not going to find it. I've got it written down. It'll be in the notes, and you could search the language. So then they go on to say Congress has the power under the 13th Amendment rationally to determine what are the badges and the incidents of slavery and the authority to translate that determination into effective legislation. So they said that Congress had the power to, because Congress has the power to create and enforce legislation based on the 13th Amendment, any violation of the 13th Amendment can be can give rise to a cause of action under 42 U.S.C. 1985 subsection 3. And then they go on to say that our cases have firmly established the right to interstate travel is constitutionally protected and does not necessarily rest on the 14th Amendment and is assertable against private as well as governmental influence. So because they stopped them from interstate travel, they also have an action under 42 U.S.C. 1985 subsection 3. And they say, in identifying these two constitutional sources of congressional power, we do not imply the absence of any other. So what they've said is there has to be an underlying constitutional authority to legislate on that right in order for it to be actionable under 42 U.S.C. 1985 subsection 3. And they also say that because the 1985 subsection 3 is the tort cousin of this criminal case, they also have to have the right. And they go under this, they talk about this in Harris and other cases. So you just take my word for it. They treat these kind of interchangeably, mostly. All right. So then from there, we go to Carpenter. Carpenters v. Scott. This is the big one where they actually tackle the First Amendment. So in Carpenter v. Scott, they conclude that an alleged conspiracy to infringe the First Amendment, let's see, right here. An alleged conspiracy to infringe the First Amendment rights is not a violation of 1985 subsection 3 unless it is proved the state is involved in the conspiracy or that the aim of the conspiracy is to influence the activity of the state. They also go on to point out that it does need to be based on some sort of animus that they found in Griffin. It has to be class-based animus. The intent has to be there. It has to be because of that protected class that they're doing it. And last, possibly the least, or probably not, because it's the most recent, at least that I'm covering, is Bray v. Alexandria Women's Health Clinic. In this one, the respondents didn't show the opposition to abortion qualifies alongside of race discrimination as an otherwise class-based, invidious, discriminatory animus underlying the conspirators' action. And respondents also didn't show that the petitioners aimed at interfering with rights that are protected against private as well as official encroachment. So where this goes, the big thing on this is that you have to remember there has to be a federal cause of action, which goes back to Griffin, and they cite Griffin on it. And the 14th Amendment requires that state action in there. And also it has to be a protected class. So and this only goes for the 1985 subsection 3. The 241 doesn't require a protected class, but it requires, it has a very strong intent requirement. But for 1985 subsection 3, it does have to be a protected class, which they go in here and they say that it's definitely race, and it may be women, but they don't actually broach it here. They say we're not addressing it. It's not, the class of women seeking abortions doesn't qualify. Women might, but they're not addressing it. So what I assume that's going to be is it's going to be the standard kind of protected classes: race, sex, religion, gender, those kind of things. So with that said, when we take it all the way back to, can a private individual violate your First Amendment right? The answer to that is no. There has to be state action, at least for both 241 and for 1985 subsection 3. There has to be state action involved. They have to intend specifically to be depriving you of your First Amendment right. And as far as 1985 is concerned, they have to be targeting you based on a protected class. And First Amendment auditor is not a protected class. So it is a urban legend that private individuals and private corporations can violate your First Amendment rights. Well, I thank you for spending the time with me on this beautiful Friday. I have a wonderful beer waiting for me, and I hope you have a great day. Happy auditing.